I rise today to talk about Americans' basic right to have their day in court. The Supreme Court has always been a towering institution, both physically and metaphorically, and until recently, as visitors walked up the steep steps of the Supreme Court's front doors, they entered underneath a mantle inscribed "Equal Justice for All." Now those bronze doors are closed to the public. Now that may have been because of security concerns, but it's hard to imagine a better metaphor for what has been happening to our court. The Roberts Court has consistently denied hardworking people their day in court, blocking them from their entrance to the courtroom. Just yesterday, as Senator Whitehouse talked about, the court erected yet another hurdle for people seeking justice in another 5-4 decision, this one called Rent-A-Center v. Jackson. On one side of the courtroom in this case was Rent-A-Center, a corporation that runs over 3,000 furniture and electronics rent-to-own stores across North America with 21,000 employees and hundreds of millions of dollars in annual profits. On the other side stood Antonio Jackson, an African-American account manager in Nevada who sought to bring a civil rights claim against his employer. Jackson claims that Rent-A-Center repeatedly passed him over for promotions and promoted non-African-American employees with less experience. Although Jackson signed an employment contract agreeing to arbitrate all employment claims, he also knew that the contract was unfair, and so he challenged it in court. But yesterday, the Supreme Court sided with Rent-A-Center, ruling that an arbitrator, not a court, should decide whether an arbitration clause is valid. Let me say that again. The arbitrator gets to decide whether an arbitration clause is valid. Let me repeat that. The arbitrator gets to decide whether the arbitration clause is valid. That's just one step away from letting the corporation itself decide whether or not a contract is fair. In doing so, the Supreme Court made it even harder for ordinary people to protect their rights at work. Justice Stevens, not surprisingly, wrote the dissent. And like he did in Gross, Stevens notes that the Supreme Court yet again decided this case along lines, quote, neither briefed by the parties nor relied upon by the Court of Appeals. In other words, the Supreme Court went out of its way to close those bronze doors and keep them closed. Clearly, this is a ruling that Congress needs to fix, and I look forward to working with my colleagues to do so. Next week, the Judiciary Committee will hold hearings on the nomination of Elena Kagan to the United States Supreme Court. Those hearings provide a good opportunity for us to examine the legacy of the Roberts Court and talk about what it would mean to have a court that instead cares about hard-working Americans.